Hello, welcome. Colin Kelly here of the Probate Hub, and delighted to be joining you today. What I wanted to talk to you today was about something that you may have come across from time to time. You will be acting for people who have been made a ward of court, and you might be aware that in those cases, when somebody has been made a ward of court, normally the ward of court office will look to have the original will of the ward. It's part of the overall protection and the supervision role of the Ward of Court Office, just to make sure obviously that there could be no tampering with a will or any attempt to make a new will while somebody is in wardship. If the ward passes away still in wardship, then you may have to prove that will or administer the ward's estate. And in that case, your natural inclination may be, listen, I'll write to the Wards of Court Office now and ask for the will to be returned. Well, it's not as simple as that. So there is a set procedure that the Wards of Court Office have in place for dealing with these type of cases. So normally what you would do would be that you would write to the Wards of Court Office and request that the dismissal procedure will be conducted. So that's the procedure of terminating the case in the Wards of Court Office. You look for a dismissal order. And at the same time, you should request the Wards of Court Office to transmit the original will over to the Probate Office. So then the Probate Office will have the original will. You then need to prove the will. So in this case, you'll be proving an attested copy of the will. To get an attested copy, you need a €15 fee card, and then you send the fee card to the Probate Office once that they have confirmed that they hold the original will. When you send the fee card to the Probate Office, you request them to send back to you an attested version of the will. And that's the version of the will that is proved. I have set out in today's blog the actual wording that you will use in your oath when you are proving that attested copy. And once all the other elements of probate are in place, such as the fact that the executors are still living and willing to act, well then it's a normal granted probate case. Hope that helps. Have a great week, and looking forward to talking to you again. If you do want to have any issues answered regarding probate or capacity or will drafting, just reach out to me on the Solicitor Query Service on the Probate Hub. Many thanks. Thank you.